Well, good afternoon, and first of all, thank you very much for inviting me. We met at Darwin dinner, and little did I know what would end up after that. Also, I've been so amazed by the diversity of the talks today. So mine's going to be different as well, so you'll keep all the mixture going. First of all, I think I ought to introduce myself and say why I've got this split personality. I'm a biotech patent attorney. And because you work in the biotech area with scientists, it's always good to have the kudos of a PhD behind you. And I always worked in my maiden name, partly because my husband is also at this university, and at least one person in this room will know that he's a bit of a maverick, so I kind of kept away from the name, sort of not admitting that I was his wife. And then my husband got knighted. Well, I tell you what, when you get the title of lady, you don't half dump the PhD quickly to get the lady title. So I'm pretentious and I don't care. So as I say, I work in the biotechnology patenting area, and I work for a local firm here. I do most of this university's biotechnology patenting. I also work for York University and Manchester and many of the other local universities. So what my perspective is today is actually what happens at the cold face. I see these restrictions and I see the problems in biotechnology firsthand. So I'm just going to say who we are. We are a firm, and of course, I happen to be probably the only service provider today, so this is the obligatory marketing slide. I apologise. So we're one of the UK's largest firms of patent and trademark attorneys. We have a sister law firm. So my background is I'm a scientist, and then I've done patent law, and so I've qualified as a European and a UK patent attorney. But we have specialised IP solicitors that we work with too, who deal with our litigation. We only deal in IP matters, and we have 7 offices, and I come from the Leeds one, which means that it's very local for me to come here, although after having lived here for 14 years, I had no idea that this building even existed, so I found it very difficult coming here today, sort of going past, and never mind. Anyway, we do a lot of foreign associate work, obviously, and I do work quite a bit with the US associates, so hence my earlier sort of comment today when Aurora gave her talk. My personal experience is that I actually find, beg your pardon to all the US people here, I actually find the US Patent Office extremely difficult to work with. I think they're quite xenophobic, and I quite often think if I could only put my applicant down as being a US citizen, I might get an easier passage. Anyway, as I say, we have an international client base. Now, today we've heard quite a bit about trademarks. Bronwyn was talking about the Jack's mark, and then there was the other trademark, the BioBrick. I'm surprised that got through because it's a little bit descriptive, but anyway. So we have, there's copyrights in terms of what sort of intellectual property there is, and what we haven't really discussed at all today is that there's copyright. There's copyright in computer programs, there's copyright in your pictures, there's all sorts of things like that, even in sort of, especially when you write a talk, you could just put a C at the end and the copyright is yours. And it covers, actually Mario, yesterday in your talk you were saying about art and how it seemed to be missed out of the latter definition in the US statutes. And of course copyright covers all aesthetic creations and literary dramatic art. And sort of the art seems to sits more into the copyright than it did with the original patents, I think. And I'd say we've done trademarks. Designs we haven't touched on here, but again, that's more widgety stuff than straight biochemical stuff. And then patents is really what we've been discussing mostly, and that's what I'm going to concentrate on. But there's also this other type of intellectual property, and that's trade secrets or know-how, which is something that in this sort of sharing share-wearing society, some people tend to keep the trademark, their know-how secret. I think the best known example, which everybody can think of, is of course Coca-Cola, which is a formulation, and that's quite easy to keep under wraps because various people have various bits of the formulation and they don't ever really get together and know what the formulation is. And that is why the actual composition of Coca-Cola has managed to stay out of the public domain for so long. Had it been a patent has a life of 20 years. Moreover, when a patent application is filed, it's published 18 months after the filing date. So had Coca-Cola put in a patent for the drink, it would have been made public 18 months after they filed it, it would have run out of patent, and there would have been so many people trying to tweak it, copy it, whatever. This way, nobody knows actually what's in it, and it's still a trade secret. Oh, another thing I wanted to say about trademarks, actually, is that, for example, with Coca-Cola, the bottle itself is a trademark because it's so distinctive. And also, for example, that you can now trademark smells. I personally wouldn't be able to tell you a different one particularly, but you can trademark smells. And of course you can trademark on the front of, I don't know if anybody's wealthy enough to have a Mercedes, but the actual logo on the front of the, it's the shape of the fender of a Mercedes is also trademarked. So there's all types of intellectual property. And also, what I found very interesting about the talk yesterday was that, and it almost pulled the rug from under my feet, is that I've worked for many years in intellectual property, and one of the discussions was, what is an invention? And I thought, oh my God, I couldn't actually positively define it. And I think that I've been thinking about it, and I think perhaps for me, personally, I would find it more easily to define an invention in terms of what it is not, what it is excluded, and then I'm hoping that everything else could fall into that. So what can be patented in the biotechnology area? Well, obviously you can patent products, so you get all your pharmaceuticals, your drugs, etc. You can get uses of those products. Now, this second medical indication has now become obsolete, but it was how you used to be able to get round. So, for example, if you had aspirin, and it was first patented as a pain relief or an anti-inflammatory, but all of a sudden you found that aspirin was a perfect healer of athlete's foot. So it has a second new medical indication that nobody knew before. You could get a patent for aspirin for the treatment of athlete's foot. And how that used to be was one of the things that I want to be talking about, and I've been asked to give practical examples and my own personal experience in biotech patenting, is that in the States you are allowed to have methods of treatment on the human body, and in Europe you may not. And one of the ways round is a bit of a wordsmith, insofar as with a second medical use and a Swiss type claim, the wording was use of a compound for the manufacture of, for the treatment of a particular disease. So you had to turn it round, the language. You can't have a method of treating athlete's foot with aspirin. You would have to say use of aspirin in the manufacture of a medicament for the treatment of athlete's foot. But now this is all gone. This is obsolete. We've had a new decision this year which makes that kind of really ugly language out the window now. We now can have purpose-limited claims. So now you can actually say aspirin for the treatment of athlete's foot in this Europe. And genes, we can patent genes. The only proviso is, and these are European Patent Convention rules here, that they must be isolated and that you must indicate a function. You can have modified genes, you can have expression vectors and probes. And similarly, patents, modified proteins, monoclonal antibodies and receptors, other small chemical compounds, cells. We know that we can actually now do certain types of even modified stem cells and cell lines, and you get methods of making all of the above. And the most exciting thing that I think has come out is a recent decision which is about the dosing regimen, which was, I think, fairly controversial because, to my mind, a dosing regimen, if you're telling somebody how to take a drug, That's more or less a method. But anyway, this is what the claim read, was the use of nicotinic acid or a compound metabolized to nicotinic acid by the body selected from a group comprising a load of names for the manufacture of a sustained release medicament for use in the treatment by oral administration once per day prior to sleep. So there's your dosing part of hyperlipidemia. And this has now been accepted, so this is quite exciting in terms of being able to open up a sort of an area now where we can actually get some dosing regimens into compounds. So what is more exciting, or rather, this is the bit that is my problem, is what can't be patented. So again, to go back to it, it's the methods of treatment on the human body by surgery or therapy and diagnostic methods practiced on the human or animal body. They're not allowed in Europe, but they are patentable in the United States of America. So to go back to Aurora's talk, and there is a big dichotomy here of what, not only of how they treat patent applications at the examination stage in terms of obviousness, which is what the Americans call it, an inventive step, which is what Europeans call it, but actually what is patentable subject matter in the first place. So I think, not in my lifetime, am I ever going to see a completely harmonised system globally, because the US is really quite out of sync, not only in terms of the obviousness, but they have a system that is first to file as opposed to first to invent as opposed to first to file, which means that there's always an uncertainty of who has the patent in the first place, because you could have somebody come out of the woodwork 5 years' time and say, actually, in the back garden in Wisconsin, I made this thing. And you will never know it, but he's got the proof, the date of where it is. Whereas the rest of the world, we are a first past the post system, first to file, and that's who's entitled to the invention. Ah, right, now here we go on to processes for cloning human beings are not allowed. Modification of germline genetic identity of human beings not allowed. And uses of human embryos for industrial or commercial purposes are not allowed. I'm going to give an example later in the next couple of slides of the Dolly the sheep and also the Edinburgh patent. An animal suffering without substantial medical benefits is not allowed. Now we talked about, we know the Harvard mouse, which is the trademark of Oncomouse here. One of the grounds for opposition, right, in Europe, when you have a granted patent, there's this period of 9 months afterwards where anybody can knock out your patent, they can oppose it. And with the Harvard mouse, once it got to that position in Europe and was granted, it had a horrific number of people who wanted to knock it out. And one of the grounds, not only on, there were other grounds, but one of the grounds that they tried to get the Oncomouse knocked out was on the grounds that it, I believe Antony's term was yuck factor, was that it was a rather sort of a cruel, possibly, animal, but the proviso is that you can justify the suffering if there's a substantial benefit to man. And my personal experience I've got a knockout mouse currently in Europe and in the US. And the inventors provided me with photos of third-generation knockout mice, and they were pretty yucky. And so I agree with that yuck term, and I said, I don't think we should put those in, because we really don't want to elicit one of these types of objections. So let's not put any pictures of these mice in, let's just describe them. So, and also the other thing is that I always make sure, on a purely practical point, that all inventors do not use their home addresses. If the animal libbers want you, they'll find you somewhere, but I'd rather not be the person that lets them find you via my patent, sort of thing. So those are ways and things that you can't patent. So one of the questions yesterday, I think that with patent law, it has to be retroactive, because you can't possibly legislate against the biobricks, because the biobricks is so new, you don't know what your invention is going to be in 5 years' time. And I also find in practice that, believe it or not, patents are they follow trends. And for example, Dolly the sheep kicked off a lot of controversy over cloning. And I think Dolly the sheep was made in the Roslin Institute, and I work with the Roslin Institute as co-applicant on some of these transgenic animals. They now are actually part of the University of Edinburgh. But the Dolly the sheep caused such a shock to the public that a lot of the stem cell backlash, I believe, came from that, in the same way that the Monsanto pulled out of a lot of their GM efforts in Europe because there was a public backlash. So my point here is that we actually react to the public as well as react to what inventions are out there. About 12 years ago in this area there was most awful drought, and that summer I did 3 gadget inventions to do with water conservation units. You know, haven't got any water, people start thinking they make inventions that are related to what's going on. When the bird flu epidemic was out, I found that I was doing a lot of bird flu patent applications because there was a lot of grant money going to research in bird flu. And so actually, you wouldn't believe it, but patents do have trends. And anyway, so just to finish off with Dolly, of why I think that Dolly caused a lot of problems is because of the public backlash. I was reading about Dolly, and she died when she was 6. And it read like an obituary. It said she had 5 surviving lambs out living. And I thought, oh. And then they said, produced the natural way. So she has rather like the mouse in the Jack's mouse. Dolly really did have a personality, an obituary to herself. Now this is a fairly controversial one, again, to go back to the point that I believe that public outcry does force some of the changes in patents, and also that you can't legislate or prevent against sort of future inventions because you don't know what they are yet. So this one is called the Engram Pattern, which, not to be confused with Dolly, who was also made in Edinburgh. This one is to do with it's the human stem cells, and the claim on the top is the claim, apart from the part I've underlined, which was granted. And what happened was that it was opposed in that period of where you get a granted patent and you can oppose them in Europe. It was opposed by 11 co-applicants, and especially Greenpeace, who are very active in any type of vaguely controversial environmental type patent. Anyway, what happened with this one is it was granted, it was opposed, and the amendment, as you can see, it's other than embryonic stem cells. It's because as it was granted, it was argued that it could read onto human germline intervention. And the other thing that happened is there's the second claim, and I've underlined there the bits that had to be taken out so that you could specifically say that the granted patent did not now include human germline intervention. It went to appeal. The sole appellant was actually the proprietor. The proprietor withdrew, so there was no actual final appeal, but he amended voluntarily. So anyway, that is the Edinburgh patent, and you've got Dolly the sheep, which kind of, I think, forced and shaped some of the stem cell reactions that we have. Now, as I say, I was asked to speak on a very personal level here, and I'm going to give you 3 case studies. One is longer than the other. This is a very short one, and this is a case that really comes from, well, it comes from the US, but it highlights the point that the US allow methods of treatment. That's the granted US claim, and their counterpart underneath is the granted European claim. But you can see how the language has to be turned around so that you then have the use of that thing for the manufacture of a medicament for use in treating. Terribly ugly language. I mean, it's horrible, and thank goodness for the recent decision, which now means that you can have purpose-limited claims. But you can. This is what happens when we get cases in from the States and their methods of treatment, is that they all have to be reworded to take into account that in Europe you can't have methods of treatment. So my second case study is, this is a local spin-out, university spin-out. I should say that I specialise in working with universities and spin-outs. And this particular case, this company prepare medical tissues for implants. And in particular, this one is a really nice knee replacement. So we've got cases here where we have one case granted in the UK, and we've got a European still pending, and we have a US as well. And what is strange here is that you can have claims in the US, again, to the methods of actually replacing the meniscus and treating meniscal injury. So that means that you could actually have a medic being caught by this infringement here, an infringement of that patent. But in Europe you can't, because you can't have the methods. In Europe you can have products obtainable by the process, and they can be used for transplantation, but you can't have the use of the products in transplantation. So the examples there, just below, is the claims that were found acceptable at the UK Patent Office. So that's a granted one, a product comprising this knee tissue, obtainable by the method that I've already described above, for use as a transplant tissue. That one was found acceptable. What wasn't was use of the meniscal obtainable by the method, by any proceeding, as transplant tissue. So you can see the level of wordsmith there. To be honest, I put them both in because I wasn't sure which one was going to go. So I thought, well, better put them both in, and then I'll be told which one they don't like, because at that time it was unclear. So that is how you can get a particular product, but you get different levels of protection for the UK and the US. Now this one is actually something that happened at the UK Patent Office. It's very rare to go to a hearing at the UK Patent Office, and this particular client, I won't ask you to guess what it is.
What?
Thank you. Well, it won't affect you. It's a handheld device for removing wrinkles. Okay? So it's very interesting to ladies of a certain age, and I want one, and he hasn't given me one, and I know they're £99. Anyway, so they're handheld devices with LEDs in them, and you hold them against your wrinkly bits. And these are the actual pictures I had to submit with the application. And quite frankly, I'm not all that impressed. But I was saying, oh, absolutely, you can absolutely see fantastic wrinkle reduction around the eyelids. Oh, periorbital gone. Oh, absolutely. So there's the before and after, and here's another before and after. Absolutely works, fantastic. And I'm saying, well, you need to see it in colour, of course, because quite frankly, I can't see very much. But although it is on the website. Anyway, it's not a great claim. And you don't have to go into too much detail here. But what I want you to see is that it's claimed as a method of cosmetically treating a superficial area of mammalian skin around above the curly eye. And we've got a very particular wavelength there, but it's cosmetically treating. Now, you wouldn't believe that this particular case caused such a rumpus at the UK Patent Office, because under Section 4A of the UK Patents Act, methods of treatment for diagnosis, a patent shall not be granted for the invention of a method of treatment of the human body by surgery or therapy. I think my claim said cosmetically treating. Anyway, it wasn't a goer, and ended up where the UK position was that my invention was in effect a method of treatment on the human body, and it wasn't patentable. And you can see this has taken 5 years to actually settle. So I argued back and I said, look, the claims have a cosmetic use and they're unrelated to therapy. And this became a point of law. It was not, it's novel, it's inventive. This was I'm saying it is a cosmetic treatment. They are saying it's a method of therapy or surgery. And it became quite a stir at the UK Patent Office because they couldn't actually... It was a fairly young examiner, so I don't think he was prepared to grant me or whatever without a little bit of an intervention from one of his superiors. It took a very long time to even get to this stage, but I counterclaimed, and so we're quoting law back to each other all the time. And there's so little UK law on this area that we had to rely on European law. And European law is given a T when it's a Board of Appeal, not the enlarged board, it's Board of Appeal. Anyway, so the term cosmetic, I was saying from another piece of case law, it's sufficiently precise to differentiate it from a product which also has a therapeutic use. Claims for cosmetic use are sufficiently distinct, even if the application might incidentally give a therapeutic effect, because I'm treating wrinkles. Yep, speeding up. So what happened was that they eventually said these claims are absolutely still methods of treatment, and I'm absolutely adamant that they're not. So I have, at this stage, I have a further piece of case law, and I also then started digging around for witness statements. It's not great to have the inventor as your witness statement, because he's obviously going to say not what you want him to, but he wants his patent. So it's not as strong as someone else. But I had a witness statement. He's a medic, and he said, to the best of my knowledge, there are no medical conditions that would benefit from the treatment of reducing wrinkles. So then we actually carried on, and there were two more pieces of case law. One of them was about removing hair. And the argument is, removing hair is beautification. There are medical conditions where you're hairy and you would want, but removing hair is for beautification. So I relied on this one. I also then had some fantastic witness statements from, she's at Leeds, she's a Professor Julia Newton-Potter. She runs the Cancer UK Melanoma Unit, and her witness statement was fantastic because she again compounded that there is no medical condition that benefits from reducing wrinkles. She said even if you can reduce wrinkles, it does not affect the propensity for you to develop skin cancer from excess sun. So I think that I had a very good case. And the only thing that they could come back to me with from case at the UK Patent Office was this bizarre thing about removing sheep follicles, and that was considered as a cosmetic method of treatment. So I found that very difficult, and then we went on with more case law, but really the bottom line is the hearing officer's decision said that in order to determine whether there was a treatment is excluded by surgery, it's a two-step process. And he says you've got to have answers yes to both. And whereas there was, and he apologised for the double negative, but where there is a non-insignificant intervention, also needed that the physical or integrity and well-being had to be restored. And the bottom line is wrinkles are not a pathological condition, and therefore it didn't matter about restoring. So therapy, the other thing that they were very keen to ensure was that the activities of a medical practitioner would not be impeded. And as I showed you at the beginning, it's a handheld device. It is used purely by an individual to put it over their wrinkles. There is no medical practitioner available, so they felt quite comfortable that there would be no impeding on one of a medical practitioner's activity. So anyway, the bottom line is that then we have one last thing to do. They said invent a step. This is where the prior art is our own device, but it's for treating bacterial infection and herpes. And my argument was they're pathological conditions. I'm not a pathological condition. We know that exposure to sunlight causes wrinkles. Why on earth would you try and treat wrinkles with light. Counterintuitive, and I believe I got caught on the hop and said, it's like prescribing cigarettes to treat lung cancer. And that was unfortunately quoted in the decision. So the bottom line is that that is something that now is used at the UK Patent Office as a seminal case for cosmetic cases. And that decision was reported in, not in the RPC, but it's on their website and has had several blogs about it. Not everybody agreed with it, but I won my case, and I'm very happy about that. Thank you.
Thank you.
One's a question or an observation, and maybe Becky or Robert can help me here. But apropos non-patentability of surgical or patentability of surgical methods in the United States, I vaguely recall that there had been a legislation passed in the recent years which either makes them non-patentable or says that they cannot be, that you can't sue anybody for patent violation of the patent. So, do you remember anything about that? Some modification has been made for surgical methods.
You can't sue a medical practitioner
right.
for violation of a patent on a medical method, but you can sue a non-medical practitioner for inducing infringement by, say, selling tools that were specifically adapted for the use of that. So it puts the focus on instruments rather than on
the practitioner. Yeah. Okay. So there is a modification anyway, a withdrawal from the absolute patentability. Secondly, though, apropos the Harvard mouse, the yuck factor, etc., I wasn't clear whether you were talking about the UK alone or the European Union.
It's the European Union. The UK.
Well, let me tell you why I'm asked the question, because when the Harvard mouse patent application came up to the European Patent Office in the mid to later 90s, early 90s, I guess it was, the moral objection was raised under Article 53A, that this was contrary to public order and morality. So what Harvard had to do was to offer reasons why it was not so. This was not the case. And they invented some ingenious reasons which are plausible. Namely, if the mouse already has an oncogene in it, then the number of mice that you have to use in order to, say, to test a cosmetic or whatever, or a suspected carcinogen is substantially reduced. So while it's cruel and inhumane, you might say, to the individually engineered mice, it is benign and beneficial for the mouse population. Then I thought that that was accepted by the European Patent Office, and then the patent was granted. So, what happened? Has something happened since then?
No, I mean, my point was that that was, for the Harvard mouse, that was a ground of opposition. And in practice, I was using it because my particular knockout mouse had some mice that looked really rather manky. And I didn't want that to be in my patent application as a matter of practice, because I didn't want to get tripped up.
Because it had come up in the Harvard mouse case, not because the...
Well, the Harvard mouse case did have it as an initial point of opposition.
Right.
And that's why it was up there. But I did it, it's on the slide, because as a point of practice with that particular set of transgenic mice that I was working with, at the end of the day they didn't look very happy or pretty, and I didn't want to get caught.
But it's not the case that the Harvard mouse has been, so to speak, knocked out.
No. The mouse is a knockout. Sorry,
I understand.
It's a knockout.
I understand. I was punning on it.
Oh, sorry.
My puns are all unintentional or bad.
Right.
Lisa, are the grounds that organisations or individuals can object to a recently granted patent the same? They have to stick to the same professional lines of argument that the inventor has to try and satisfy, or can they be ethical, social, moral, much wider?
The grounds for opposition are on all of the patentability issues, and also whether it is sufficiently disclosed and whether there's been added matter. So you get all of the novelty, notice of industrial applicability, etc. and the grounds of exclusions, plus added matter, plus insufficient disclosure.
Lisa, one thing you maybe touched on a little bit at the margin, but one thing that I get very confused about because I don't have to deal with it is I never know which jurisdiction I'm supposed to be paying attention to when it's in Europe, whether it's the EPO, the convention, or whether it's the EU, and
Right.
how, which rules apply to which things and how. So could you say
The
just a little bit about that?
EU is an economic
Right.
group. It has nothing to do with the EPC as such, because Switzerland is an example that is
Right.
a country that is, never been in the EU, but is part of the European Patent Convention. And the hierarchy is that how a lot of these countries, for example, you cannot get a direct French patent from an international application. You have to go via Europe, and you have to do that for a number of other countries. So what tends to happen with an international patent application is you come out, you go into Europe, you're examined in one place under one language with one examiner, and the other contracting states will accept what that examiner says. So if you're granted in Europe and you then pay all your fees, etc., you can get, as long as you've designated those states, you will get all the other ones. So it doesn't matter as such, because you've got the central European process for grant. But the downside is, it's also centrally where you can get opposed. We don't have an opposition procedure per se in the UK. So
What I get confused about is a lot of the laws that set these criteria for interpretation of patent law seem not to be, there is no entity for passing laws for the EPC, right? There is a legislative process for passing laws for the EU. So
right.
how does this,
how do you affect EPC law? Is that what you're right? Well, it's funny because as we were sitting downstairs having a cup of tea, I told you exactly that. It was a US client who had, and how I know this is because I had to phone up and find out how to do it. It was a US client who we were being held up on, we were objected to, and we were going to be rejected in Europe on the grounds of sufficiency. Sufficiency being I've not disclosed, or there's not enough disclosure in the application that you filed to allow somebody else to go away and repeat that invention. And in this particular instance, it was because there was not a deposit of a monoclonal antibody. And the difference in US law, which again goes back to my point earlier that I don't think in my lifetime I'm ever going to see harmony, is because in US patent law you can make a deposit at any time during pendency of the application. In Europe, the rest of the world, that deposit has to be made at the date of international filing or filing date. So they had missed the opportunity in Europe, so they hadn't made the deposit, so we had no sufficiency there. So my client said to me, "Can't you get the law changed?" Yeah, okay, I'll try. So I thought, well, actually, it's an interesting question. So I phoned up the UK Patent Office. I looked up on the website of how you get it changed. I phoned up the UK Patent Office. The guy was out. It's the representative who's from the UK Patent Office, which is on the European Patent Convention that meet every so often. So I phoned him up and I thought, well, he's not going to call me back, is he? So anyway, he did. And how you get him, or how the UK could try and get a law changed, is I had to lobby my professional body, which is the Chartered Institute of Patent Agents. They then contact the UK Patent Office. The UK Patent Office will then go forward with the recommendation from my Chartered Institute to the European Patent Office, and when they have their conventions of law changes, that is when it gets there. So I said to my client, I don't think we'll meet the 2-month deadline. So it's long and drawn out.
I've got a question, if I could. Going back to Tony's talk, and not least his...
If he can wake up.
Well, not least his description of the Wimbledon effect.
Yeah.
Where one thinks, oh, yeah, that's right, until you hear the opposite. You think, well, that sounds right, too. Tony left us, if I understood, with a vision of where ethical decision-making lies as rather below his level. That is to say, there's only so much that can be legitimately expected at the level of TRIPS negotiations. The rubber meets the road ethically at much lower levels, the level of individual decision making. That sounded right. And then you gave us your talk, and as I understood you, you rather described the virtues of an adversarial system, which is to say you try to do the best for your client, everybody else tries to do the best for theirs, and out of all of this, as if by an invisible hand, we hope, comes the right decision. So, as it were, the ethical outcomes reside somehow at a system level rather than the level of individual actions and reflections. So, do you agree with me that these don't quite fit well together, or?
Yeah, I think the problem is that I possibly don't think higher than I have to work within these particular confines, and so that is where I know that my what is patentable and what isn't, my work there, and I guess I don't question go up even further, and I think that perhaps there's a level in the middle of where you don't actually come down to the real nitty-gritty, and so I think there's probably a level there where the two minds don't actually completely meet.
Which don't. I think we have to stop there. Let's thank Lisa for...
Thank you.